Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner in our San Diego office, and I'm here today with Miki Matrician, the co-managing partner of our Boston office. Hey to you, Miki. How are you?
Hi, Kim. Love that you're sitting in front of the pine forest.
I know it's so different than sitting in front of the brown in California, although I guess we call it golden, the golden state there. But yeah, I love the greenery here. It's super nice. Yeah, so that makes it pleasant to talk about our installment for Rapid Fire Wednesday today, which is the impact of mergers and acquisitions on H-1B1, H-1B, and E-3.
Awesome. Yeah, I think it's a pretty timely discussion because mergers and acquisition activity is picking up a little bit this year now after a slower year in 2023. And I think it's really an important topic because when companies are going through the due diligence for mergers and acquisitions, there are so many important financial and legal pieces. And often immigration consequences are the last thing that companies really want to think about. And, a lot of companies do have an international workforce. And so it's really important to conduct due diligence steps from an immigration perspective to ensure that the transition of key employees is successful and smooth.
Yeah, that's true. So when HR global mobility professionals learn of an upcoming merger or acquisition, right, some type of corporate reorganization, it's really important to alert Immigration Counsel. And even though today we're just focusing on U.S. immigration, H-1B, H-1B1, and E-3, there also could be global immigration issues that are involved as well. So that's one thing for them to keep in mind. So the first step is to provide, the Immigration Counsel with a list of all foreign national employees of the target company that is being acquired. And with that list, they should include their immigration status as well as expiration dates. Those are really, really key and important pieces of information. And then, HR and global mobility professionals can talk with Immigration Counsel about what changes are anticipated to take effect upon the close of the deal.
Yeah. And when we're talking today about H-1Bs, the same principles basically apply for H-1B1 and E-3 visas because all three of those visas are specialty occupation, non-immigrant visas that are based on a certified labor condition application. So in terms of whether an amended petition or amended application is required or not, just because of a corporate restructuring like a merger or acquisition doesn't mean that an amendment is always required. So long as the new corporate entity is what's called a successor in interest, meaning basically that the new entity is going to absorb the interests and obligations of the original petitioning employer, and the job itself remains the same, except for the identity of the employer, then an amendment is not required. Kimberly, do you want to talk about kind of the data points that we need to know in order to make the determination whether an amendment becomes necessary?
Yeah, sure. So those key data points we typically refer to as terms and conditions of employment. And we have several criteria or categories that we look at. One is, will the foreign national continue to work in the same worksite location as, with the company that's being acquired? Would there be any additional changes to the terms and conditions of employment, like change from full-time to part-time? Or is there going to be a decrease in salary? So an increase in salary is not going to have a negative impact on an individual's status or the need for an amendment, but a decrease in salary can definitely have a major impact. So then we also want to ask, are there going to be any changes in titles of these individuals? Are there going to be changes in the roles and responsibilities, right? The duties of the position. Specifically, is there a substantial change in what the individual's duties are going to be in a potentially new role? And then with these key pieces of information, we as Immigration Counsel can analyze whether an amended petition for the H-1B classification or the E-3 is necessary. So those are some of the key things that we're going to dive into and look at.
Yeah. And if there is no amendment required, then basically, upon the deal close, the foreign national's previously approved petition would still stand and they'd be able to continue to work for the acquiring entity based on that previously approved petition. For international travel, they would, upon coming back to the United States, they would present the I-797 approval notice if it was a USCIS petition for that acquired entity, along with the existing visa stamp and their passport. But they should also carry a letter from the new acquiring entity stating that it is a successor in interest to the previous approved H-1B employment, and that the terms and conditions of employment of the approved H still remain the same. I would just say a note that, companies and foreign nationals should always consult Immigration Counsel before finalizing any travel plans and definitely before departing the United States because there are case-specific situations to be factored in.
Yeah, absolutely. That's a really good point. So, as you mentioned, talking about amended petitions, but even if an amended petition is not necessary, there are still some steps that HR and global mobility professionals should take in order to ensure compliance in the event of a corporate restructuring or reorganization, like merger and acquisition. So, Miki, can you talk about what those requirements are?
Yeah, absolutely. So, if an amendment is not required, HR professionals need to make sure that they maintain a list of the H-1B employees and also put in their public access file document that contains a few key things like the affected labor condition application number and the date of certification, explanation of how the actual wage is set for the new employing entity, and then also the federal employer ID number for the new employing entity as well. There also needs to be on that notice a sworn statement that essentially the new company is assuming all of the obligations and liabilities and ensuring, upholding any attestations made in that labor condition application that was filed by the previous company. And as a reminder, the public access file is a retention file that needs to be made available to any member of the public that asks to see it or Department of Labor upon request. Kimberly, I think it's a good time to talk about other compliance considerations too. And as the I-9 guru, could you discuss the key points that HR and global mobility should be cognizant of for I-9s in a mergers and acquisitions scenario?
Yeah, of course. I'd like to talk about I-9. So there are, potentially two options. One is if the employer treats the seller's employees as new employees, they would do new I-9s for those employees. Or if they don't treat them as new hires, they could, assume the I-9s that have already been completed. So with that comes some potential costs, right? So the company would want to do their due diligence because if they take over, essentially assume the I-9s, they're going to take over the liabilities as well. So that is one thing to keep in mind with I-9 compliance is know what I-9s you're acquiring, what potential issues are in the I-9s. And then from there, the company can make a determination with respect to what is their, liability, what are potential fines, and then is it an option for them as a strategic maneuver to re-I-9 the employees in order to minimize any potential issues. So that's definitely something to keep in mind, discuss with Immigration Counsel before making any type of strategic moves in order to ensure that the company is understanding what their I-9 compliance is and if there are any major issues with the I-9s. For instance, if there are major I-9s that are missing for a lot of employees. So those are some key things that they want to keep in mind as they're going through the merger and acquisition deal.
That is so critical. Thanks, Kimberly. I just cannot emphasize enough the importance of advanced planning that really could help avoid derailing the smooth transition of key talent. And, Immigration Counsel should be guiding HR professionals through a streamlined process that, limits the deal information and analysis to one or two designated professionals in the immigration team so that the information is contained really only with that team. And that could address some of the concerns or anxieties of, general counsel and C-suite to say to them, this is how, our immigration counsel handles this. And also just not only to educate them, but remind them that global mobility or HR needs to be looped in ahead of the deal and that they don't need to be worried about the confidentiality piece. So I would encourage all global mobility and HR professionals to kind of have those conversations in advance. So that's a wrap for today's session on the impact of M&A on H1, H1B1, and E3s. And join us next time for a discussion on 5 key takeaways and strategies if there is a Trump 2.0 administration post-election.
That'll be an interesting one. I know we like talking about that. So if you don't already, follow us on LinkedIn, on the WR immigration page or our individual profiles. And then every week we do turn our Rapid Fire Wednesday into a newsletter that we release, and you can subscribe to that newsletter in the comments. So thanks, everyone, and good to see you, Miki. Have a great day.
Thanks, Kim.